Roll call for Monday, March 1st, 2021. Anderson,
Here.
Baldwin,
Here.
Beitman,
Here.
Boner,
Here.
Bouchard,
Here.
Case,
Present virtually.
Cooper,
Here.
Driscoll,
Here.
Ellis, French,
Here.
Murphy,
Here.
Guru,
Here.
Hicks,
Here.
Hutchings, James,
There.
Kinski,
Here.
Kolb,
Here.
Cost,
Here.
Landon,
Here.
McCune,
Here.
Nethercott, Pappas,
Here.
Perkins,
Here.
Rothfuss,
Here.
Salazar,
Here.
Schuler, Scott,
Here.
Steinmetz, Wasserberger,
Here.
President Dockstader.
Here,
30 present.
prayer by Pastor Sean Sells, Calvary Baptist Church. Pastor.
Let's pray. Heavenly Father, we're so grateful for you, for the liberty you've given us as a nation. Lord, we thank you for the great creation that we have that we get to enjoy. Lord, today I would pray for our state. Lord, we would continue to pray that you would give us political and civil, religious liberties that we have. Lord, help us to know how to go forward as we seek to find your will in all of these things. Lord, I would pray for these legislators here today, for these senators. Lord, I would pray that you would bless them with wisdom and insight, that you would help them to lead and legislate in justice and in truth. Father, I thank you so much for all that you've given them in wisdom and insight. Lord, I pray that there would be hope and direction forward. Lord, we know that our state is struggling in ways with different things connected to the coronavirus and the loss of life that has come with that. Lord, we know that there are budgetary issues and so many other issues. We know the university lost a couple of students last night. And so we would just continue to pray for your grace and mercy for us, that you would show us how we can best represent you in this world. Lord, I thank you so much for your son, Jesus Christ, and the mercy that he's shown me and that he desires to show each person here. Lord, I know that you love each and every one here more than anyone else. And so we pray this in Jesus' name. Amen.
Senator Salazar, would you lead us in the pledge?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Pastor. Thank you, Senator. Reading and correction approval of journal. Will the reading clerk please read the journal committee report?
Mr. President, your Journal Committee reports that the Journal of February 5th, 2021 has been read and recommends that it be approved. Senator Kolb, Chairman.
Are there any objections? Objections? There being none, the report is adopted. Under new business, we'll now introduce our new Senate employees. Majority Floor Leader Driscoll.
President, I move the following name first. Place nomination.
Oh, sorry about that. Okay.
Let's start over. Mr. President, I move the following named persons be placed in nomination as employees of the Senate and they be voted on collectively.
Reading clerk will read the names of the employees in their respective positions. We're going to have our reading clerk just get a little closer to that mic as he speaks.
Cheryl Brown, Assistant Chief Clerk. Randy Fetzer, Reading Clerk. Linda Chassen, Leadership Secretary, Co-Historian. Ron Kasicki, Doorman. Ron Van Vost, Doorman. Judy Eatman, Judiciary and Corporation Secretary, Co-Historian. Lavelle Van Vost, Education and Revenue Secretary. Don Shepard, Agriculture and Travel Secretary. Michael Cunningham, Labor and Minerals Secretary. Kim Lovett, Transportation Secretary. Belle Henrich, Watchperson. Andy West, Watchperson. Sue Broyles, Clerical Staff Support Messenger. Jackie Whitehead, clerical staff support, messenger.
Thank you. You've heard the motion that the persons on the list just read be made the employees of the Senate. All those in favor, say aye. Aye. Opposed? No. Motion carried. On behalf of our chamber, I thank the continuing staff members as well as welcome our newest staff members to the Wyoming Senate.
Mr. President, can we give our new staff a hand?
Thank you. Okay, we're new for our doctor nurse of the day. We're going to be doing something just a little bit different this time around. For non-emergency medical referrals, the University of Wyoming Family Practice will be helping us. 307-214-4508, and we'll make sure that you get that number if you need it at your desk. Today in Wyoming history, in 1872, this was a big one. 1872, 149 years ago, Congress authorized the creation of Yellowstone National Park. So we're right behind that, the Department of Tourism stepped in. So quotes for the day. If you want happiness for an hour, take a nap. If you want, nobody gets to take a nap. If you want happiness for a day, go fishing. If you want happiness for a year, inherit a fortune. And if you want happiness for a lifetime, help someone else. Chinese proverb. Status of the session reconvenes. The Senate files must be in to the LSO in final form by 12 noon today. With that, we'll go to reading, introduction, reading, and reference of bills. Senate File 92, first reading of the bill.
Senate File 92, Public Hospitals Out of County Operations, sponsored by Senator Case.
Senate File 92 is referred to Committee Number 3, Revenue. Senate File 93, first reading of the bill.
Senate File 93, WICHE Repayment Program Veterinary Medicine Students, sponsored by the Appropriations Committee.
Senate File 93 is referred to Committee Number 2, Appropriations. Senate File 94, first reading of the bill.
Senate File 94, Prohibiting Coerced Vaccinations, sponsored by Senator Bouchard.
Senate File 94 is referred to Committee Number 1, Judiciary. Senate File 95, first reading of the bill.
Senate File 95, Election of State Health Officer, sponsored by Senator Bouchard.
Senate File 95 is referred to Committee Number 7, Corporations. Senate File 96, first reading of the bill.
Senate File 96, Homicide Amendments, sponsored by Senator Hutchings.
Senate File 96, referred to Committee Number 1, Judiciary. Senate File 97, first reading of the bill.
Senate File 97, State Employee Longevity Pay Prospective Repeal, sponsored by Senator Hicks.
Senate File 97 is referred to Committee Number 3, Revenue. Senate File 98, first reading of the bill.
Senate File 98, sponsored by Senator Ellis, Bail Source Hearings.
Senate File 98 is referred to Committee Number 1, Judiciary. Senate File 99, first reading of the bill.
Senate File 99, Unfair Employment Practices, Offsite Lawful Activities, sponsored by Senator Ellis.
Senate File 99 is referred to Committee Number 9, Minerals. Senate File 100, first reading of the bill.
Senate File 100, Internet Freedom Prohibiting Discrimination, sponsored by Senator Steinmetz.
Senate File 100 is referred to Committee Number 1, Judiciary. Senate File 101, first reading of the bill.
Senate File 101, Pen Registers and Trap and Trace Devices, Authorization, sponsored by Senator Nethercott.
Senate File 101 is referred to Committee Number 1, Judiciary. Senate File 102, first reading of the bill.
Senate File 102, Unclaimed Cooperative Utility Deposits and Payments, sponsored by Senator Driscoll.
Senate File 102 is referred to Committee Number 7, Corporations. Senate File 103, first reading of the bill.
Senate File 103, Resident and Non-Resident Hunting License Issuance and Fees, sponsored by Senator Hicks.
Senate File 103 is referred to Committee Number 6, Travel. Senate File 104, first reading of the bill.
Senate File 104, Anesthesiologist Assistance, sponsored by Senator Pappas.
Senate File 104 is referred to Committee Number 10, Labor and Health. Senate File 105, first reading of the bill.
Senate File 105, disclosure of private cryptographic keys, sponsored by the Blockchain Committee.
Senate File 105 is referred to Committee Number 9, Minerals. Senate File 106, first reading of the bill.
Senate File 106, Transportation Statutory Amendments Number 1, sponsored by Senator Landon.
Senate File 106 is referred to Committee Number 8, Transportation. Senate File 107, first reading of the bill.
Senate File 107, Transportation Statutory Amendments Number 2, sponsored by Senator Landon.
Senate File 107 is referred to Committee Number 8, Transportation. Senate File 108, first reading of the bill.
Senate File 108, Career and Technical Education Terminology, sponsored by Senator Cooper.
Senate File 108 is referred to Committee Number 4, Education. Senate File 109, first reading of the bill.
Senate File 109, Board of Dental Examiners Amendments, sponsored by Senator Cooper.
Senate File 109 is referred to Committee Number 10, Labor. Senate File 110, first reading of the bill.
Senate File 110, Small Claims Procedures, sponsored by Senator Nethercott.
Senate File 110 is referred to Committee Number 1, Judiciary. Senate File 111, first reading of the bill.
Senate File 111, School of Energy Resources Budget Submittal, sponsored by Senator Anderson.
Senate File 111 is referred to Committee Number 9, Minerals. Senate File 112, first reading of the bill.
Senate File 112, Insurance Discount for Accident Prevention Training, sponsored by Senator Landon.
Senate File 112 is referred to Committee Number 8, Transportation. Senate File 113.
Senate File 113, Business Ready Communities Amendments, sponsored by Senator Wasserberger.
Just for the record, Senate File 113, first reading of the bill. Senate File 113 is referred to Committee Number 9, Minerals. Senate File 114, first reading of the bill.
Senate File 114, State Land Leases, sponsored by Senator Boner.
Senate File 114 is referred to Committee Number 5, Agriculture. Senate File 115, first reading of the bill.
Senate File 115, Education Pupil Teacher Contact Time, sponsored by Senator Cost.
Senate File 115 is referred to Committee Number 4, Education. Senate Joint Resolutions, Senate Joint Resolution Number 2, first reading of the resolution.
Senate Joint Resolution Number 2, Convention of States, sponsored by Senator Beitman.
Senate Joint Resolution Number 2, referred to Committee Number 9, Minerals. Senate Joint Resolution Number 3, first reading of the resolution.
Senate Joint Resolution Number 3, Federal Suspension and Orders on Oil and Gas Production, sponsored by Senator Cooper.
Senate Joint Resolution 3, referred to Committee Number 9, Minerals. Those are introductions, reports from standing committees.
February 23, 2021. Mr. President, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 30, Pandemic Response Review Task Force, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chair. February 23, 2021, Mr. President, your committee number 3, Revenue, to whom was referred Senate File 85, Property Tax Reporting and Exemption, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Baldwin, James, Pappas, and Schuler. No, Senator Case. Senator Case, Chairman. February 23, 2021, Mr. President, committee number 2, Appropriations, to whom was referred Senate File 71, Strategic Investments and Projects Account Repeal, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinski, Perkins, and Steinmetz. Senator Perkins, Chairman. February 23, 2021, Mr. President, your committee number 2, Appropriations, to whom was referred Senate File 72, Financial Counsel and Reporting Budget Reductions, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Guru, Hicks, Kinski, Perkins, and Steinmetz. Senator Perkins, Chair. February 23, 2021, Mr. President, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 76, Broadband Development Program Amendments, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Driscoll, Nethercott, and Scott. No, Senator Case. Senator Driscoll, Chairman. February 23, 2021, Mr. President, to Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 33, Physician Assistance Amendments. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman. February 23, 2021, Mr. President, to Committee Number 3, Revenue, to whom was referred Senate File 70, Fingerprinting Fees. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Baldwin, Case, Pappas, and Schuler. No, Senator James. Senator Case, Chairman. February 23, 2021, Mr. President, to Committee Number 2, Appropriations, to whom was referred Senate File 79, Medicaid Billing for School-Based Services. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, Chairman. February 24, 2021, Mr. President, Committee Number 4, Education, to whom was referred Senate File 68, Absenteeism in Public Schools. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Beitman, Ellis, Rothfuss, Salazar, and Scott. Senator Scott, Chairman. February 24, 2021, Mr. President, Committee Number 4, Education, to whom was referred Senate File 83, Gillette College Community College District. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Beitman, Ellis, Rothfuss, Salazar, and Scott. Senator Scott, Chairman. February 23, 2021, Mr. President, to Committee Number 2, Appropriations, to whom is referred Senate File 82, Local Impact Assistance Payments. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Guru, Kinsky, Perkins, and Steinmetz. No, Senator Hicks. Senator Perkins, Chairman. February 24, 2021, Mr. President, to Committee Number 10, Labor, Health, and Social Services, to whom is referred House Bill 4, engrossed, Mental Health Professions Practice Act amendments. Respectfully report same back to the Senate with the recommendation that it do pass. Ayes Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, Chairman. February 24, 2021, Mr. President, to Committee Number 10, Labor, Health, and Social Services, to whom is referred Senate File 34, Born Alive Infant Means of Care. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, Chairman. February 24, 2021, Mr. President, Committee Number 10, Labor, Health, and Social Services, to whom was referred Senate File 47, Clinical Laboratory Regulation, Direct to Consumer Exception. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, Chairman. February 23, 2021, Mr. President, Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 88, Ownership of Fossils and Artifacts. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Ellis, Guru, Landon, Salazar, and Schuler. Senator Ellis, Chairman. February 24, 2021, Mr. President, Committee Number 1, Judiciary, to whom was referred Senate File 49, Deferral of Criminal Sentence Amendments. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Cooper, Cost, and Nethercott. No, Senators French and Kolb. Senator Nethercott, Chairman. February 25, 2021. Mr. President, Committee Number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 40, Wyoming Money Transmitters Act Amendments. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. February 24, 2021. Mr. President, Committee Number 1, Judiciary, to whom is referred Senate File 6, Public Works Contracting Requirements Amendments. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. February 24, 2021, Mr. President, Committee Number 1, Judiciary, to whom was referred Senate File 87, Voyeurism Amendments. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. February 25, 2021. Mr. President, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 3, Automatic Vehicle Identification Systems, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, and Pappas. No, Senator McEwen. Senator Landon, Chairman. February 25, 2021. Mr. President, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 89, Public Utility Safety Lights, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman. February 25, 2021. Mr. President, committee number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 4, Airport Districts, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Landon, Chairman.
Thank you. Consideration of bills on general file. Mr. Majority Floor Leader, we are at that order of business, consideration of bills on general file. Oh, Senator Landon. Absent objection, Senate File 3 will be re-referred to Appropriations Committee number 2. Thank you. Majority Floor Leader Driscoll.
Mr. President, I move the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Aye. Opposed? Motion carried. Senator Perkins, welcome home to your old chair.
All right. Yeah.
How does this work this year?
Committee of the whole will come to order. The first bill for our consideration is Senate File 52, Insurance, Mental Health, and Substance Use Parity. Reading clerk, please read the bill.
Senate File 52, Insurance, Mental Health, and Substance Use Parity, sponsored by the Labor Committee, was referred to Committee number 10, Labor, Health, and Social Services, which returned a committee recommendation that it do pass. Ayes, Senators Baldwin, Bouchard, Furphy, McEwen. No, Senator Hutchings. Senator Baldwin, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator Baldwin. Uh-oh, hang on. Senator Baldwin.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, I do so at the recommendation that Senate File 52 do pass. And for an explanation of the bill is the good senator from Albany County.
Oh, that senator from Albany County. Thank you. Senator Furphy.
Well, thank you, Mr. Chairman. I'm going to present Senate File 52. This relates to providing mental health and substance use using telehealth medicine. President Trump passed 2 executive orders, as we heard in committee. Order number 13941 to improve rural health through telemedicine. And he also approved Executive Order 13954 to help reduce suicides in rural communities. So that's what this bill is related to. And so if you would go to the bill itself and you look on the first page, line 1, it's relating to insurance, providing equivalent benefits and reimbursement related to mental health and substance use services delivered remotely. So if you go to the down below on line 10 on page 1, statutes 2620-701 and section A, this is pertaining to all individual or group health insurance policies providing coverage. And if you go to page 2, it's relating to only those policies that provide mental health and substance use. So not all policies provide that. If you go to line 4, it says the commissioner may enforce, subject to the provision of this section, the Mental Health Parity and Addiction Equity Act of 2008. So if you drop down to line 15 on page 2, it says no policy or contract providing mental health or substance use coverage shall, go to line 19, Romanet I, deny coverage for mental health or substance use services delivered using remote audio or audio visual delivery systems to a person not physically present with the delivering healthcare provider if coverage would be provided for the same service when delivered in person. So that's important. So we're saying we ought to provide the same services, whether they're in person or remotely. So if you turn to page 3, Romanet II, what the commissioner is responsible for is they cannot charge a co-payment, the insurance company cannot charge a co-payment, deductible, or co-insurance amount to a person receiving mental health or substance use services through remote audio or audiovisual delivery systems that is higher than the co-payment, deductible, or co-insurance amount charged for the same services when delivered in person. So they have to reimburse the same to the mental health provider, whether the person is present or doing it remotely. Romanet III on page 3 says they cannot reduce any payment or provide to a healthcare provider, once again using audio, visual, or remote, to an amount that is less than the payment or reimbursement that would be made to the health care provider rendering those services in person. That is basically the bill. And Mr. Chairman, I think it's important for our state to provide these services. We heard particularly a lot of veterans are hesitant to go to a mental health provider if they're physically seen going into that provider. However, they may utilize the service if they're doing it remotely. So we think this bill is important, and Mr. Chairman, I recommend approval of Senate File 52.
Thank you, Senator Furby. We're on the bill. Discussion on the bill. Questions? Discussion on the bill or questions on the bill? Senator Kinski.
Thank you, Mr. Chairman. A question for the senator from Albany County or other members of the committee. During the COVID crisis, there was a special regulation came down that applied to the community mental health centers that allowed them to provide remote services and still receive Medicaid reimbursement as well as the reimbursement that comes from the state. this bill limits itself to individual or group health insurance policies. Do we need to extend the protection of this to reimbursement by Medicaid or state reimbursement for mental health providers? Thank you, Mr. President.
Thanks, Senator Kinski. Other questions or discussion? Other questions or discussion? Senator Beitman. Hang on, Senator. There we are. Senator Beitman.
It's green now. Thank you, Mr. Chairman. Good to see you back in the big chair today. My question is regarding the term substance use as opposed to substance abuse. Obviously there was a decision made to make that change. I was wondering what the discussion was behind that, because I've never heard the term substance use in this kind of element. Usually it's a substance abuse issue. So any clarity on that would be great. Thanks.
Thank you for that, Senator Beitman. Other questions, other discussion, other questions, other discussion. There, Mr. Chairman, or Senator Furphy, would someone like to answer those questions? Mr. Chairman, Chairman Baldwin.
I didn't hear the second question entirely, so I'll let Senator Furphy answer that one. Concerning Medicaid question, that coverage was extended during the crisis. And I believe the proposal is to extend that further. I don't think there's any need to put it in this bill, but I think if it comes that we need that, then we can look at that down the road. But right now that remains covered, and I believe it will be covered down the road as well. So right now, I don't believe there's any need to extend that further in the bill. And for the second part of the question, I couldn't hear it.
So let's go ahead and Senator Beitman, yeah, Senator Beitman, you want to stand up and ask your question again? It had to do with substance use instead of substance abuse was part of it.
There it is. Okay. Yeah, I just noticed it says substance use throughout the bill from the bill title on down. And typically when we're talking about substance abuse, we use the term substance abuse. So if there was discussion in the committee, or if that's just how the bill came out, just a quick question on that. Don't need to, delay the process here.
Thank you, Senator Beitman. Senator Bouchard.
Thank you, Mr. Chairman. I want to circle back first to the first question. We've had the stakeholders at the table when this bill was being discussed in committee, and we would have certainly made any changes that needed to be done at that time when it comes to Medicaid. So I want to assure the body that we've vetted this bill on that situation. On the name of the bill, substance abuse in the bill, we've done a lot of changes over the last couple of years, moving in a direction which I am glad we have moved to make sure we've allowed those professionals to be recognized in our state. And that's one of the reasons that's in this bill, is to make sure that we have parity in that realm as well. Because what we're doing here, whereas some people might think this is against free markets, it's actually not. If we let's step out of this mental health range for just a second. And in health and labor, we have discussed telemed till we're blue in the face. And I'm not exaggerating. We've done everything we could do to push it out and to make it available and to have doctors use it. And I will say that as much as we've had such a huge problem that's been created by COVID, the only thing that I can tell you that I can say is an honest to goodness benefit is the fact that now telemed has become so prolific. And so I can tell you I use it when I visit with my doctor, and they can charge the same rate when they're doing that. And quite frankly, they spend more time with me on that than they do in an office because of the time constraints of the office. But anyway, that said, that I think what we're doing here is we're moving the free market over into with this bill because we're having parity. So I want you to understand a provider could charge less. They could charge less and decide to charge less in a public pay situation. And it's also going to apply backwards that way too. So this is a good bill. I ask the body to support it.
Thanks, Senator Bouchard. Other question or discussions? Other question or discussions? Senator Hutchins.
Chairman, I just wanted to express my no vote. My concern was over what I saw in the bill, that we would have audio and then audio visual being reimbursed in the same light. And my objection has been cleared up on page 3, lines 9 through 14, when it talks about they will not be services to the amount that is less than the payment or reimbursement for only audio visual. I was just so concerned that a doctor could call someone and talk to them over the phone and get the same amount of pay as a doctor who had the audio visual. So my objection's been cleared up. Thank you, Mr. Chairman.
Senator Baldwin.
Thank you, Mr. Chairman. Just to clarify that just a little bit more so it's clear in everybody's mind, and this is personal experience. That is audio, visual, and audio. There are times when the patient doesn't have access to video. When the patient, and I will give an example of that. I had a patient that lived in Bridger Valley that only had a mobile phone. It wasn't, good. It was a flip phone. Somebody in here has a flip phone. I don't remember who. But they did have audio connection with me. Now, important to note is the documentation, everything that's done in that visit, including talking with the receptionist, includes getting all their medical history, everything. Documentation is exactly the same as it is in telemedicine, or if they're in my office. So the documentation standard, the threshold they have to meet is the same. Of course, we prefer to see them in person. We prefer to see them like we're seeing these gentlemen on the screen here. But when it's not possible, audio is available, but it follows the same standards and is available. Senator Bouchard said something very important, and that is telemedicine and mental health. We were talking about it beforehand. We were starting to use it, but because of COVID, now we're using it a lot. Some offices used it exclusively. Now, as COVID starts to calm down, we're keeping it in the spectrum. We're not going to it exclusively, but we're using it a lot. And it's a tool that we've used not enough in the past. It's something that's coming of age. We'll be using it more, and it's a valuable tool. Hopefully we get people in on telehealth that wouldn't come in otherwise, as Senator Furphy talked about. Some people with mental health have a stigma and don't want to come in. This gives us a key. We can get them in when we might not be able to. So it's an important healthcare key, important mental health care key that we haven't used enough, that now we can use more. This bill makes it available so we can pay the same, so we keep that parity between all the systems. And I would encourage an aye vote on the bill.
Thank you. Senator Bouchard.
Thank you, Mr. Chairman. I would like to talk a little bit about the audio part of this, but it has nothing to do with the mental health side. Some of my experiences that I've come across on the other side of medical is that there are times where doctors need to just make that call, and they need to make a phone call, get something done. And I've seen it in these COVID cases where they're handling, things are happening rapidly, and they may be on telemed with them, and then they're turning around and making a phone call within a couple of hours. So that's all part of the realm of what's going on in here. It's just, it's making it convenient. The whole telemed situation needs to be convenient for everyone involved. This is just doing this on the mental health side. It's going to be similar to what's already happening on the other side of medical. Thank you.
Thank you. Other question or discussion? Are you ready for the question? Question having been called. The motion is that the committee of the whole do adopt or do approve or vote in favor of Senate File 52. All those in favor, please say aye. Aye. All those opposed, no. Motion carries. Senate File 52 has passed committee of the whole. Next bill for our consideration is Senate File 44, Solid Waste Cease and Transfer Program Funding. Will reading clerk please read the bill?
Senate File 44, Solid Waste Cease and Transfer Program Funding, sponsored by the Minerals Committee. As referred to Committee Number 2, Appropriations, which returned to committee recommendation that it do pass. Ayes, Senators Hicks, Kinski, Perkins, and Steinmetz. Excused, Senator Garreau. Senator Kinski, acting chairman. Originally referred to Committee Number 9, which returned to committee recommendation that it do pass. Ayes, Senators Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson absent. Senator Beitman, acting chairman.
heard the reading of the bill. What is your pleasure? Are we going to go to Senator Anderson remotely? Or are we going to go to Senator Rothfuss in chamber? Chairman Anderson, are you going to do this or are you going to delegate this?
Mr. Chairman, I think Senator Beitman would be the one to go to.
Oh, okay. Well, Senator Rothfuss, go ahead.
Oh,
The chamber, that would be reasonable. But so, Mr. Chairman, I move that when the committee of the whole rises to report to do so with a do pass recommendation on Senate File 44, and for an explanation of the bill, I'm pretty sure it's good Senator Wasserberg. that
Okay,
true?
well, I'm glad it's not Senator Beitman.
It could be me. It's the season.
Senator Wasserberg. Senator Wasserberg.
Thank you, Mr. Chairman. Actually, this is Senate File 44. As you know, it is an old friend. We've had this program, I believe, now for 7 years. There was a federal appropriation, and we've used that money to do the cease and transfer program, which is moving solid waste to an area landfill and disposing of it properly. And so this is actually, I think, the 7th time that we've had a very similar bill on the Senate floor. And we've been working through a lot of different landfills. And so on page 3, line 7, the difference here, we start a carcass management project to take care of animals that get hit on the highway and die for various different reasons. But the reasons why we're appropriating $100,000 to that is diseases like brucellosis and chronic wasting disease. And so we're trying to take care of those. Moving down, you'll see that Upton receives 1.3 million, Newcastle 1.2, Moorcroft 1.5. So that's northeastern Wyoming, Crook and Weston counties. Glen Rock 1.6 million. North number 2 is 1.65 million. Thermopolis 2 million. Rollins, the city of 780,000. Thermopolis 2.5 million. Bags 2.5 million. Lingle 350,000. Bighorn County 2.8. Newcastle 1.1 million. And then Cokeville for $1 million. Uinta County Solid Waste, Bridger Valley 4 million. LaGrange 1.4 million. Moorcroft 500,000. Upton 1.5 million. And finally, Park County landfills for 351,000. And I believe, Mr. Chairman, that explains the bill. So I stand for questions at this time.
Thanks, Senator Wasserberger. We're on the bill. Are there any questions or discussions on Senate File 44? Senator Hutchings.
Thank you, Mr. Chairman. My question is on page, I think you said 3, line 7, on the carcass management project. There's a bill, it's called affectionately roadkill. If and when that bill passes both houses, could we possibly reduce the amount on this particular carcass management project? Thank you, Mr. Chairman.
Senator Wasserberger, you're eager to answer that question. Go ahead.
I don't know what that answer is, but I will tell you that, yeah, that bill would actually have a partial impact on this. But the real reason for the $100,000 appropriation is more than anything to protect the wildlife that we have now from brucellosis and chronic wasting disease and those things. So disposing of the body properly that's left, if someone doesn't take it, that would be very important. But I don't have an answer for that. That's a good question, Josh.
Thank you. Thank you, Senator Wasserberger. Are there further discussion or questions on Senate File 44? Are you ready for the question? Question having been called, All those in favor of Senator Rothfuss's motion that when the committee of the whole rise to report that it do so with a favorable recommendation on Senate File 44, say aye. All those opposed say no. Senate File 44 has passed committee of the whole. The next bill for our consideration is Senate File 19, Public Health Emergencies Immunity Amendments. Will the reading clerk please read the amendment?
Senate File 19, Public Health Emergencies Immunity Amendments, sponsored by the Judiciary Committee, was referred to committee number 1, which returned a committee recommendation that it do pass amended. Ayes Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman.
Thank you. You've heard the reading of the bill. There are some amendments. Senator Nethercott.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the do pass recommendation of Senate File 19, Public Health Emergencies Immunity Amendments. To explain this good little bill and the amendments, I will call on myself, Mr. Chairman. So there are 2 amendments, if I can have them read in at this time.
Okay, we'll do study committee number 1. Will the reading clerk please read the amendment?
Senate File 19, the Standing Committee Amendment number 1, page 1, lines 9 and 10, delete.
Thank you. Senator Nethercott.
Thank you, Mr. Chairman. Good senators, as you may recall.
Let's go ahead and move the amendment if you would, please, Senator.
I can certainly do that, Mr. Chairman, or I can wait until the appropriate time in the bill. I'll explain the bill first and then move the amendment and discuss the amendment. This is a unique bill, good senators, where the amendment really is the onus of the bill. And that would be the committee of the whole amendment number 1 that would be before you. So just for purposes of clarifying what it is you're going to be asked to vote on, really in substance, it would be the committee of the whole amendment number 1 to Senate File 19. To give some background to this good little bill, senators, you recall we're in a pandemic. As a result of that pandemic, there has been extreme concern regarding tort liability issues associated with the virus in order to protect our business. From the May special session we did provide additional protections to our business community for COVID-related liability concerns. Those were presented to the state in 2 primary ways. One was in Senate File 2 from that special session, as you might recall, where we provided workers' compensation coverage to businesses and identified that COVID-19 would be a compensable injury under workers' compensation. That was really profound work that the legislature did during that time, which provided significant protections to businesses and employees across the state, because workers' compensation is the sole and exclusive remedy. And so if an employee contracts COVID, their only remedy is through the workers' compensation fund. So they do have a protection, a remedy through the workers' compensation fund, and businesses cannot be sued as a result of that. As you also might recall, there was a presumption associated with that. So very important to understand that protection currently in place as a result of the good work as the robust bill presented to us in Senate File 2 in the special session. As you also recall, there were additional individually sponsored bills brought out that created a lot of discord between the 2 bodies, and a compromise was made, adding the additional protection for business entities that if they are compliant through good faith compliance with health orders, that they would have immunity. And again, I want to distinguish between 2 concepts of which you're being asked to discuss. One is a procedural process associated with defense of tort liability, and then one is immunity. And immunity certainly means you can never be sued. So what we did in the May session was we granted immunity for compliance with health orders to business entities in addition to healthcare professionals. Recognizing that the public still wanted more business protections, the Joint Judiciary Committee was tasked with taking that issue up. And simultaneously, other efforts were brought forth due to the popularity of providing protections to businesses. Of note, there is not a single case in the state of Wyoming, and very, very few across the country, regarding tort liability to businesses. Not a single one, despite reaching over 500,000 deaths nationwide, and certainly hundreds in the state of Wyoming for deaths and injuries, but there isn't one. So of note regarding the elevated concern, but we will respond to the needs of our business community accordingly. So the Joint Judiciary Committee went forward and presented to you Senate File 19. Good senators, if we look through the bill on page 1 is in line 12 is immunity from liability. We changed the words substantial compliance with orders, guidance, or instructions of a health officer of a city, town, or county. So it's substantial compliance as a requirement that there wanted to be additional specificity of what it meant to follow a healthcare order. And that language was added. The amendment will remove that. If we move down to line 7 of the bill, acts or omissions of the person or entity that caused another to be exposed to or contract the disease, agent, or toxin for which the public health emergency is declared. That language is added concerning acts or omissions of the person or entity that caused the other to be exposed. That's a particular component of the bill, recognizing you're familiar with a lot of this conversation from working this concept in May. I'm not going to drive through it any more thoughtfully. Then on line 19, subparagraph D, the immunity provided in subsection A of this section shall apply only to actions or omissions causing exposure to or the contraction of the disease, agent, or toxin for which the health emergency is declared. Good senators, this is the bill. In discussing the standing committee amendment, further efforts were designed, and I would move standing committee amendment number 1 to Senate File 19 and urge your no vote on this particular amendment. What it does is it changes on page 2, lines 1 through 17. We deleted that entirely and inserted that language. Good senators, I'm asking you to vote no on this particular amendment because the committee of the whole amendment actually deletes this amendment and addresses a more robust protections associated with COVID immunity, which is what our business community so desperately desires. And so, question being called on.
We are on the amendment. What's the point of order? Yes, the amendment was just moved a moment ago.
Question being called on the amendment, Mr. Chairman.
The question is, shall the Senate adopt standing committee amendment number 1 to Senate File 19? All those in favor say aye. All those opposed say no. No. The noes have it. The motion has failed. We're back on the bill. Senator Nethercott.
Thank you, Mr. Chairman. I move committee of the whole amendment number 1 to Senate File 19 and ask for your favorable consideration. Oh, I thought we had him read in.
Senate File 19, Committee of the Whole Amendment number 1, delete the.
Mr. Chairman, I would move committee of the whole amendment number 1 to Senate File 19, ask for your favorable consideration. Good senators, this is essentially a comprehensive amendment that I think affords the state of Wyoming the greatest level of protections in response to concerns over tort liability for COVID. There's a number of concepts associated within it. One, we insert the concept of assumption of risk for COVID-19 exposure, as you can see on the amendment on pages 4, really through 3 of the amendment. Assumption of risk is a concept that we're familiar with, both in the Wyoming Recreational Safety Use Act and as a part of our general common law associated with assuming known risks associated with inherent activities. So as we know from the Wyoming Recreational Safety Use Act, we granted these types of immunities when there is an inherent risk, for example, with rodeo. So we have said if you get on the back of a bucking bull and you get hurt, the rodeo can't be liable, nobody is responsible. You assumed the risk of getting on the back of a bucking bull, even if the rodeo suggests and requires that you wear a helmet or other type of protective gear, that does not diminish the inherent risk associated with riding a bucking bull. Similarly is the concept of going out during a pandemic or a global health crisis, that you are assuming the risk of exposure to a highly contagious communicable disease, and no one can truly protect you from that. And there is an inherent risk of doing that. That does not mean that you are still not required to follow health orders or any of those other issues associated with it or take personal responsibility for protecting yourself. But it does say that by going out, you are assuming the risk of being exposed to inherent exposure to a communicable disease. And as a result of that, liability is very hard to attach because you've assumed the risk associated with that inherent activity. Again, similar to the Wyoming Recreational Safety Use Act, where we ask those entities that want to avail themselves of the act associated with those inherent activities to post a notice. You can see on page 3, lines 6 through 12, the language or verbiage that should be posted for those businesses. And what it says is, under Wyoming law, there is no liability for an injury or death of a person entering these premises if the injury or death results from the inherent risks of contracting or being exposed to COVID-19. By entering these premises, you are accepting and assuming this risk. Pretty expansive tort liability protections. Further, adding another layer of protections, we add a section 2. On page 3 of the amendment, line 41 is really where it starts. Any healthcare provider, person, or entity shall be immune from liability for damages in an action involving a COVID-19 liability claim unless the person seeking damages proves that the healthcare provider, person, or entity took actions that constitutes gross negligence or willful or wanton misconduct. Nothing in this subsection shall be construed to limit any other immunity available under law, including the immunity provided in subsection A of this section, which is the original law that's currently been on the books for decades. And then there's a definition of a COVID liability claim. Then on the very last kind of concept associated with this amendment on page 4 is a controversial piece, which was highly disputed and continues to be disputed from those interested in this issue. So page 4, lines 4 through 7. Any acts or omissions constitutes the basis of a COVID-19 liability claim shall be stated with particularity and shall be proven by clear and convincing evidence. So there's a standard of clear and convincing evidence, which is a higher standard of proof for a plaintiff to have to prove in order for liability to attach. It's the highest standard of proof in a civil context. And so which would be different than other types of standards of proof associated with tort liability. But as a result of the extreme concern associated with COVID-19, this particular amendment, I believe, provides the greatest level of protections. The body should know that there is one criticism about this amendment, which is that it's not retroactive. I'll let the body take its own consideration about that piece and consideration, but this is the amendment. Good senators, I'd stand for questions and ask for your favorable consideration.
Yeah, Mr. Chairman, I'd like a little discussion as to why in the previous health order that we passed in the special session, it didn't specifically call out COVID-19. And this one narrows it. So what this is only going to result to liability associated with, the way I read it, to this specific pathogen. So if a new one, so let's assume that we have COVID-19. We know there's variants out there right now. And it gets mutated, and the CDC calls it COVID-20. And so COVID-20 starts to run through, then all of our businesses have lost all immunity from any liability associated from somebody coming in to do their business. And so I'm really concerned that we've now taken this and we've narrowed this down to a specific name, and those names change from year to year based on the variants that come out. And I think this is a very dangerous to go down there and just address this as a single entity or bacteria or virus in this particular case. I think the other bill, when we broaden that, would cover all of those circumstances, but just a little explanation and maybe some discussion as to why this is so narrowly focused. Thank you, Mr. President.
Thank you, Mr. Chairman. Mr. Chairman, you know, I have some questions regarding the impetus and need for this, particularly on the basis of what the good chairman of the Judiciary Committee mentioned in the beginning, which is that we really haven't had any circumstances where these lawsuits have been coming forward. And so when we contemplate the current system and what we're operating under, I'd ask the Judiciary Chairwoman to describe the current state of affairs and how courts would receive complaints at this point in time, because based on my understanding, Mr. Chairman, from the actions we took, it's basically a level playing field right now going into the court where a plaintiff and a defendant would be on equal ground. It's sort of an equal standard. They'd have access to the courts. The courts wouldn't deny access to a plaintiff. The court would listen to arguments, and then based on the circumstances and the evidence, the court would provide a ruling on again, a level playing field between the plaintiff and the defendant. It's my understanding that this legislation really is trying to steer the playing field to the point where the defendant has a superior position. The businesses have a superior position to our constituents, just the folks that walk into the business, in a way where there is an inherent bias in statute that the courts should consider, where the evidentiary burden on the plaintiff, which is equal right now, would be disproportionately biased against, and effectively the defendant, which would be a business interest, would have a superior standing. That's the first question, is kind of how is it now in terms of if random plaintiff and random defendant went to court, how would the court treat it? How would that be different after this? And why would we see that specifically as necessary? And I'll have a follow-up, but thank you, Mr. Chairman.
Thanks, Senator Rothfuss. Senator Brightman.
Thank you, Mr. Chairman. And just to follow up on that, good senator's question, my question is, in the past, has there been in Wyoming law people that have sued a business owner because they've gotten sick from whether it be the flu or the common cold? Is this a common thing for people to sue? And if so, what have the courts done and how have they handled it? Obviously, I'm sure they've handled it without this kind of legislation. Curious how that would interplay here, following up with the good senator's question. Thank you.
Thank you, Senator Brightman. Senator Nethercott.
Thank you, Mr. Chairman. Going in chronological order, and starting with the good senator from Sheridan County, I'm not aware of any litigation associated with contracting the flu. Proving what's called a plaintiff's case or a tort case requires essentially 4 elements. Duty, do you have a duty to the person? So certainly there's a question whether or not a business has a duty to a customer. Whether or not that duty was breached. So did the business cause the harm? Whether or not the business actually caused the harm, causation is the 3rd element, and damages. In the case of a communicable disease like COVID-19, I think the pushback on the ground from those in the legal field are, this is not an issue. Plaintiffs' lawyers aren't really excited about COVID-19 because why? It's such a hard case to prove. So our scientists the world over are struggling with understanding how it's contracted. 1 mask, 2 mask, no mask, 3 mask. How much sanitizer should one use? What is the incubation period? Can you get it from a shipment package coming into your home? Are you going to get it from the grocery store? And so trying to prove which business an individual contracted the disease, well, is pretty impossible. Plaintiffs' cases are also typically taken as a contingency basis. So the lawyer is not getting paid on an hourly basis, and they're only going to get paid back based on an award of damages. So that goes to the other concept, which is pretty important in damages. Damages means there's 2 types, compensable and punitive in a tort case. Compensable is based on the actual damages received. So getting the flu, what are your actual damages? You may have healthcare costs, but your insurance company will pay for that. And so your insurance company would have to get paid back through a process called subrogation. So it's out-of-pocket expenses for your medical expenses associated with the flu. How much are those? Assuming you don't need to be hospitalized and understanding that best practices even now is not to use a ventilator, most people don't needing to be hospitalized for significant periods of time. The damages aren't very extensive. And then, of course, death, which is certainly important, but above all, most folks aren't dying from COVID-19, they're surviving, but it is extreme. So the damages involved with this type of case, I don't think are as high as most plaintiff lawyers would like to see, resulting in it being a cost benefit analysis for them to take up the costs associated with proving the case. Punitive damages apply when somebody commits really gross misconduct, and the damage award is intended to punish the defendant for gross misconduct to deter it in the future. And those are really up to the jury standards. Again, I think it's important to note that we have survived for the past year without any much stronger laws on the books, and there's been no litigation brought forth. That doesn't say it won't come, but I do think that it is probably unlikely and a very small number. However, the business community is very much concerned about this issue, as one can imagine. There are continuing concerns, and we want to make sure Wyoming is a place that's open for business and our businesses feel comfortable being open for business. And so those balances have been struck associated with those fears and concerns. The amendment is limited to COVID-19, really as an effort to provide further compromise regarding the type of immunity that we are granting in a tort liability case. This would be the only circumstance that I'm aware where immunity would be granted, not just a higher threshold or a standard of proof, but immunity would be granted. And so limiting it to the experience that we know and understand as opposed to something unforeseen. I think of note and very, very important is the concept that the law currently on the books, and as we amended in May, is not being changed. And that would be 35-4-114A. That was the law originally passed, I think in the 80s, and then again in 2003 and 2008. Regarding immunity for healthcare professionals responding to a pandemic, we expanded that to business owners. It's my understanding that it's never been triggered. And so there's never been litigation concerning this particular piece. So I hear the concerns that it doesn't go far enough because it's limited for COVID-19. And I hear concerns that it goes too far. And I hear concerns that it's completely unnecessary. Hopefully everyone can find a compromise with providing the maximum protections I think that can be afforded for COVID-19 limited to that aspect. So happy to stand for further questions.
Thank you, Mr. Chairman. Really appreciate the Chairman of Judiciary and the conversation on this front. Like all of you, back home, this is one of the most important things we've been talking about for a long time. I represent a district that you all know about that has a lot of healthcare workers who live there. And so I have a particular interest in the language related to that. And anecdotal stories seem to work sometimes, so I'll use one. And I don't think I'm outing anybody, but so these friends of mine decide that they're going to go bird hunting in the state where the big heads are. And one of those friends is a healthcare worker who decides not to go because of these concerns that we've been talking about for the past few minutes. His friends come back from that trip, and as we all know, that particular state that I referenced spiked dramatically over the past year and really had some struggles. Well, guess what? A couple of those individuals ended up with COVID. I'm just wondering in my head, as I look at proven by clear and convincing evidence, I'm wondering if that bar is reached if our healthcare provider had gone on that trip and then inadvertently brought it back to his practice or her practice, as the case may be. I maybe a little more conversation on that front as to just for us lay people, that's a pretty good bar. I mean, clear and convincing is a high enough bar, is it not? That would hopefully be a situation where Is that bad enough to step out and maybe go bird hunting? And does that reach this threshold that we have in our amendment today? Thank you.
Thanks, Senator Landon. Senator Schuler.
Thank you, Mr. Chairman. Just another follow-up question on page 4, the amendment we're talking about. Just wondering if the way it's worded right now is if our business communities feel comfortable with that. That's probably my biggest concern. I think they're the ones who probably got hit the hardest of anybody, with the COVID crisis. And so I just wonder if that particular addition on page 4, lines 4 through 7, if the business community at large is comfortable with that. Thank you.
Thank you, Senator Schuler. Senator Nethercott.
Thank you, Mr. Chairman. To respond to those questions, the business community is happy with that. There's quite frankly nothing more they could ask for on that front. It is the highest burden of proof that they can have in a civil case. Concerning the scenario presented by the good senator from Natrona County, it depends on a number of factors. It sounds like the bird hunter was also a medical provider who left the state and exposed herself to COVID-19, came back and provided treatment to patients. I would need a significant number of more facts to understand how that contraction occurred for the patient from the provider, concerning whether or not that provider used preventative measures or chose not to. It's always questionable whether or not a provider is spreading contagious diseases that are lethal to their patients, and an inquiry into that must take place. So I would say any plaintiff, any patient that was harmed by that provider would have a very, very difficult case as a result of this amendment. But whether or not that conduct rises to gross misconduct or willful and wanton, I don't know. I would be concerned if my provider was exposing me to COVID-19. So, but I think it'd be a hard case.
Thank you, Senator Nethercott. Senator Hicks.
Mr. Chairman, just a couple of questions. Trying to understand the flow of the bill. So I've got a question on that, but a follow-up on my colleague from Uintah County's question is the input from the business community. This is a committee of the whole amendment, and I was wondering, to answer that question, when was there public testimony taken by the business community, whether they do or do not, or they think this is inadequate, because it is a committee of the whole amendment? That's the first question, Mr. Chairman. The second question is, and I'm trying to get the flow of the bill. So it provides that a business owner has to provide notice on the door with a sign. The language is there. It has to be a minimum of 1 inch high. So if we take that component and then we go to page 3 and we look at subsection D, and it talks about constitutes gross negligence or will or wanton misconduct. So the question I would ask is a hypothetical situation, Mr. Chairman. So if you have a business and you have that sign posted, but for whatever reason, the cleaning staff took it down to wash the windows or the door and forgot to put it back up, somebody comes into the business and because the sign isn't posted, is that gross negligence on the business then? How would that work? I'm trying to understand where the gross negligence comes in associated with the requirement of the business to put the signage up to notify people. So just an explanation of how that works would be beneficial for me understanding the amendment.
Thank you, Senator Hicks. Senator Nethercott.
Thank you, Mr. Chairman. Concerning the question on page 4, lines 4 through 7, I'm a bit perplexed at the level of inquiry into this. There is no greater standard of proof that could be afforded to the business community. This is in their best interest. It is what they have asked for at public meetings throughout the interim, both to the travel committee and the #1 committee. where they have asked for this both in written materials and in numerous recitations requesting for this burden of proof. So the Joint Judiciary Committee evaluated this particular standard of proof. Great debate was heard about it from both sides. We had a number of stakeholders against it, and we had a number of stakeholders for it. So what's important for this body to consider is that this particular standard of proof errs in the favor of the business community, and it is what they are asking for. It is a divergence from what our normal customary laws are regarding tort liability. It affords greater protections by requiring a higher burden of proof. It is what they are seeking. Significant public testimony was heard on that particular issue through both committees. Concerning what is gross misconduct or willful or wanton misconduct and the signage, this is a law that was adopted from the Wyoming Recreational Safety Use Act. And I specifically went to that because it's something that we're familiar with and support for things like ski resorts and rodeos and other types of activities that have inherent risks with them. The signage is something just to make consumers aware of the inherent risk, but it's not a requirement for the immunity to attach. A failure to have the sign up would never result in a finding of gross misconduct or willful and wanton misconduct. Something that would rise to the level of gross misconduct would be, let's take, for example, in a rodeo scenario, somebody putting something intentionally on the bull to make the bull more aggressive, or not putting the right, equipment on the bull, making it more unsafe than it already is, right? And so it would require that level of unreasonable conduct that would shock the conscience associated with it, that we really can't continue to operate reasonably as a society if someone behaves at that level. I think something similar to that could be having something knowingly exposed or having COVID-19 on it and leaving that out for someone to expose themselves to naively could be a potential scenario, but I caution me coming up with hypotheticals on the floor. So hopefully that answers those questions.
Mr. Chairman, got a question of a little different nature. And, I'm not a lawyer, and I trespass in these areas with some trepidation. My understanding is that most of the tort liability cases that are brought in this state never go to court, never wind up in a trial situation, and are settled ahead of time. And that defending one of these can be quite expensive. And the way that somebody who is innocent gets out of one of these without vast expense is to get the case dismissed early on. And what I'm afraid is, suppose we get a case that, it's hard to prove, but it may be possible to prove. And is the standard of evidence here that's proposed good enough? So your business person can get the case dismissed, or because it's some kind of a form of negligence, is the judge always going to say, no, that's a jury matter? And then it may be hard to prove, but it may be expensive to defend, and they may be able to negotiate a settlement in a circumstance where they probably can't win the case in court, but you never know with the jury, and people aren't willing to take a chance. And that's where my concern is in this whole area, that, and I don't know how the amendment affects it. Are we, with this amendment and this bill, are we adequately protecting the business community against the kind of extortionary tactics that you do see as they try to force settlements that may or may not be justified because of the cost? And is there a way to do that? So, Mr. Chairman, I am treading in areas I do not understand, and I'm asking for explanation that can give me some understanding.
Thank you, Senator Scott. Go back to Senator Nethercott.
Thank you, Mr. Chairman. Simply put, we cannot shut down the courthouse doors for COVID. It is my belief that this amendment affords the greatest protections to the business community, allowing them, if they get sued, to move very quickly for a successful dismissal. That's all we can do. As we know, this body passed the Skier Safety Act. I just saw in the newspaper a resort being sued. So all we can do is provide the legal framework, and we cannot prevent people from suing. But I do believe that this amendment allows for those business communities to move rapidly into a state of successful dismissal. Insurance companies play a big role in that, as opposed to the litigants. But that's the reality there. I'm aware of no further protections that could be afforded to the business community other than retroactivity and still being constitutional with accessing to our third branch of government. So a lot of considerations that way, but I do believe our business community is well protected. There's no litigation, and that's important to calm these fears while we are attempting to encourage our businesses to have the protections that they need.
Senator Guru.
Thank you, Mr. Chairman. On for the amendment. I don't purport to speak for the entire business community, but I do own one. So I'll speak to it. I'm in favor of the amendment, and I think that it does as much as it can do. I've been sued in my business and some of the over the years, and sometimes it just happens and you go through it and work with your insurance company. But as earlier testified, one of the big things that hits me about this, and it's used to be said a lot by a senator from this very city, we don't know what we don't know. And the problem is so widespread with COVID. The good chair was speaking of the problems and the unknowns associated with workers' comp. Up to date, workers' comp of Wyoming has spent over $500,000 taking care of folks who have COVID-19. What we don't know is how much it's going to cost in the future. We have no idea. And we won't know for years. I have no idea what those costs could be. So business owners could be on the hook for liability of unknown totals of dollars through no fault of their own or not enough knowledge. I'm in the food service industry. There's a restaurant in our town that shut down because people stopped going because they were violating the rules. They got written up. It was in the paper. People stopped going there and the restaurant doesn't exist. So at least up in my neighborhood, they take that stuff kind of serious. So I think this bill is necessary. I think it does. We do work on it on our own, and as water's going to seek its own level. But for now, I think this bill is necessary and the amendment's necessary. Thank you, Mr. Chairman.
Thank you, Senator Drew. Senator Rothfuss.
Thank you, Mr. Chairman. On and against the amendment, and probably the bill as well, because I do fully agree, Mr. Chairman, with the good chairwoman of the committee number one, that this really is as good as it can be. I think she accurately describes that from the perspective of a business. But our judicial branch is supposed to be balanced. It's supposed to be fair. It's supposed to be blind justice where all have equal access to it. This is the thumb on the scale of justice, right? This is taking the blindfold full off and saying, businesses, we're going to bias towards you because we care more about business than we care about the workers, the customers, the patients, the general public. This is full bias towards business. And I realize that that's probably fine with many folks, but that's the concern I have is that this particular amendment and this bill really is based on a concern that is grounded in the idea that we do not want fair access to the judicial branch, that we don't want equal standing in the eyes of the courts, that we're afraid that the courts will simply be used for a extortion factory as opposed to justice. But Mr. Chairman, I would remind the committee of the whole. I would remind the committee of the whole of Article 1, Section 8 of the Wyoming Constitution, that courts are open to all, that all courts shall be open, and every person for an injury done to person, reputation, or property shall have justice administered without sale, denial, or delay. It doesn't say some are more equal than others. All are equal. And if we get into the business of providing presumption in the courts of who gets to win the lawsuits and who gets to lose the lawsuits because we think it's better for our political interests, or certain constituents over others, I think we're going down a dangerous road, Mr. Chairman. It's not just providing more protection to businesses, because the judicial interests are a fixed pie. It's a balance. It is a scale. Providing additional interests and protections to one party means providing less to the other party. It has to. If there was a way to provide them both with better interests, I'm on board. Let's protect both sides better. But we can't. It's a zero-sum game. When we look out by providing this incredibly heightened standard for businesses, we do so by providing a lower standard of access to our regular everyday citizens, the folks that don't own the businesses, the folks that just want to show up there. And you think about what's in the interests of business, honestly. If I have a business where I know that they're looking out for me and I'm protected when I go there, and I have another business where upon arrival, I know that all of the risk has been waived and there's no liability, I know which of those businesses I'm probably going to go to. So, Mr. Chairman, I understand that we want to protect our businesses, but this seems a bridge too far. Thank you, Mr. Chairman.
Thank you, Senator Rothfuss. Senator Cole.
Thank you, Chairman. I stand on and for the amendment. I think it does what we need to do to protect our businesses. And we need those businesses, especially now in these times. But more importantly, I like to speak to the woke attitude that's sweeping this country. It's an attitude that everyone, I guess, is responsible for everything, and everything can be avoided somehow through a lawsuit or an action that could be, it's totally unforeseeable. We couldn't foresee this. Life is what it is. You get sick, you die. You're born, you live. And we need to protect our businesses. I'm tired of this attitude that everyone should be sued because you feel like someone did something wrong to you, when it's in fact part of life. A virus is part of life. We've lived through it. We will live through this. God bless the folks that have passed away, but we need to move on and we need to protect our businesses. Thank you for my time to comment.
Thank you, Senator Cole. Senator Bouchard.
You know, I didn't know if I was going to chime in on this bill or not. But I keep hearing all these words about protecting businesses. I don't know of any of these cases that have happened, where we're going after businesses because somebody got COVID. But when I see a title of a bill that says Public Health Emergencies Immunity Amendments, We need to be protecting the businesses from our government. That's where the problem was. That's where the real problem where businesses were put at risk by what our government did. And here we are talking about dancing around protecting businesses with this language. I don't think it's necessary. I mean, I may vote against the amendment. I may vote against the bill because I don't think this bill really does anything for businesses.
Is your mic on? Mr. Chair, thank you.
They've got me, I've got to turn it off, otherwise it watches me all the time. Thank you. So anyway, that works. Do I have to do that all again? Yes. Okay, no. By your vote, Senate File 19 has passed Committee of the Whole. The next bill for our consideration is Senate File 5, driving under the, Senate File 15, temporary licensing and permitted authority 2, which is interesting because we haven't had one yet, but will the reading clerk please read the bill?
Senate File 15, Temporary Licensing and Permitting Authority 2, sponsored by the Corporations Committee, was referred to Committee Number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Driscoll, Nethercott, and Scott. Senator Driscoll, Chairman.
Heard the reading of the bill. What is your pleasure? Senator Driscoll.
Thank you, Mr. Chairman. I move that the committee rise to report it, do so with a favorable recommendation on Senate File 15. And for further information, I call on Senator Nethercott.
Senator Nethercott, long time no hear from you. Senator Nethercott, floor is yours.
Tough morning for you all, good senators. I apologize for hearing my voice all morning. To explain this bill, this is another kind of COVID response type bill that we heard in the Corporations Committee over the interim regarding challenges with administering tests and continuing education requirements for professionals and their licensure needs as a result of the unavailability of examinations and continuing education courses from all of those being canceled over during the pandemic. And so what this bill does in total is allows for those boards to waive those requirements when those requirements are not able to be met as a result of some type of an emergency similar to COVID, and allowing for that flexibility, not that they are forever waived or not that those obligations to continue with those requirements to keep up their licensure or examination, but just that they will be temporarily delayed. And so it makes a lot of sense to afford this flexibility to those licensing boards. I'm happy to stand for any questions.
Thank you, Mr. Chairman. Just the language, I understand that the intent certainly with the D paragraph implies that it's a temporary waiver or modification as its basis, but the language in paragraph B seems to suggest that if the conditions in Romanet 1 through 3 apply, that there can be a waiver or modification of the statutory examination. But then I don't necessarily see where that is required to be temporary, if that makes sense. So if you're temporarily eligible, then you can make the waiver or exception. But that waiver exception doesn't seem to have to be temporary even though the language in D indicates that you might have ongoing examination. So a little more clarification on how we're getting at that conclusion from the language that's there. Thank you.
Thank you, Senator Rothfuss. Senator Scott?
Mr. Chairman, what you've got here is emergencies can be caused by COVID, can also sometimes be caused by bureaucratic considerations. You have a requirement for an examination, the examination ceases to be given. You have a requirement for continuing education, there's not enough of it available for a number of reasons. And it may be it may come on you suddenly, so you need the waiver just to function. But then you get into the paragraph D, where if it's going to be a permanent condition, then you may need to change the statute. And we have seen that a number of times, and most often it's occurred when we require an examination and get too specific and the examination goes away. And then you need to change the statute. And that has happened, and we've managed to get by. This gives you a license to be common sense. And paragraph D says that happens and it's lasted more than 2 years. It gives people guidance as to which of the legislative committees they go to get the statute, to get the ball rolling on changing the statute. If it's health related, you go to committee 10. If it's not health related, you go to committee 7. And so that does contemplate that we weren't going to get a permanent waiver. We're going to get the statute changed if for some reason the original scheme in the statute no longer works because something is unavailable. And where that has happened is with specific examination requirements.
Thanks, Senator Scott. Senator Nethercott.
Thank you, Mr. Chairman. Just direct the body's attention to page 3, lines 8 through 10, where it states no waiver or modification granted under subsection B of this section shall have a duration of more than 4 years.
Thank you very much. Further discussion? Are you ready for the Senator Rothfuss?
Thanks, Mr. Chairman. So I guess the nature of the concern is a circumstance where, for example, you won't have a test for 2 months. You've got some crisis, something comes up, could just be, bad weather for a while or something. So the decision is made by a board to waive a testing examination, we'll say. And that opens the door for effectively no less than 2 years of free ride without the examination despite statute, but certainly not more than 4 years of free ride without complying with the statute. And I guess my question is that comfortable? And maybe it is, maybe that's fine. And maybe I'm seeing things that go bump in the night here, but the moment one of these waiver circumstances apply, the board has broad authority to make substantial changes counter to statute that will last for quite a while, because there's no while statement. It's not while these things are true. It's a trigger statement where when one of these things is true, then we get to change substantially the requirements for certification. And in a lot of cases, that might not be that big of a deal, but I'm confident that some of the boards we're talking about, it really does matter to us that they take the test and that they are appropriately certified. So was that discussed, and are there factors that can provide me with additional confidence that this would not be abused, this isn't a concern, and we shouldn't have the language while in there somewhere? Thank you, Mr. Chairman.
Thank you, Senator Rothfuss. Senator Scott.
Mr. Chairman, two points relating to that. You have the provision in subsection C, page 2, line 16, relevant licensing or certifying authority may impose reasonable and necessary restrictions or requirements in a license certificate to practice affected by a waiver or modification granted so that, and the one I've heard considered is that you get somebody allowed to practice in this state, but you say for a period of time, you didn't take the examination, so you've got to be under the supervision of somebody who is already licensed. I think that's the one is you're most likely to see. You could have a requirement, say continuing education wasn't available this year because of the COVID. The requirement could be, okay, next year you've got to use that to catch up on the continuing education once it's available. Maybe if you waived an examination and got somebody licensed to practice, you never go back and have them take that examination. After a few years of practice, you found out whether or not they were competent, and if you had reservations about it, you put a practice under restriction that maybe can be removed later or is of limited duration. You give the board license with that language to be sensible about the particular circumstance. But you aren't going to say, okay, you've got a waiver to practice for 2 years or 4 years, then you got to take the examination. I suppose they could with this language impose that restriction. I doubt that they would. It would depend on the circumstances, but you're giving the licensing board with that subsection C the ability to use some common sense and deal with the circumstance. And most of the boards did that anyhow, whether it was legal or not. We had at least one board where we had people, new graduates coming into the state, had been offered jobs, had not been able to take the final, the examination, and the board said they didn't find a way legally that they could let them practice in this state. And that was what triggered the bill. And as an emergency response to COVID, we didn't have that second session. So it wound up as a bill making this permanent. There was a back and forth between Committee 10 and Committee 7 as to who was going to do it. And Committee 7 did it basically based on the schedule. They were the one that had the convenient meeting time to get the ball rolling on this initially, when we thought we were aiming at another special session. So it really is, this doesn't work if your boards don't have any common sense. This gives them the legal authority to proceed and use some common sense, given the particular circumstance you have. And it does have the ultimate protection of the limitation on the duration of the waiver and the requirement to come back and change the statute if something is permanently changed.
Is there further discussion? Are you ready for the question? All those in favor of Senator Driscoll's motion that when the committee of the whole rise and report that it do so with a favorable recommendation on Senate File 15, please say aye. All those opposed, say no. Motion carries. And thank you for those appearing online for raising your hand for an aye. Those that did. Thank you. Senate File 15 is passed committee of the whole. Our next bill for our consideration is Senate File 9, State Employee Moving Expenses. The reading clerk, please read the bill.
Senate File 9, State Employee Moving Expenses, sponsored by the Transportation Committee. Was referred to Committee Number 8, which returned to committee recommendation that it do pass amended. Ayes Senators Furphy, Landon, McCohen, and Pappas. Excused Senator Anderson. Senator Landon, Chairman.
Thank you. You've heard the reading of the bill. What is your pleasure, Senator Landon?
Thank you, Mr. Chairman. I would move that when the committee of the whole rises to report it, do so with a due pass recommendation on Senate File 9. There is a small standing committee amendment. I would ask that that be read in at this time.
Will the reading clerk please read the amendment?
Senate File 9, Standing Committee Amendment Number 1, page 2, line 10, delete.
Thank you. Senator Landon.
Mr. Chairman, thank you. This little bill, fellow senators, comes out of the interim work of your Transportation Committee over the past year. And while it's a fairly simple looking bill, it has garnered, my understanding is, quite a little bit of conversation. And that is because we do have a statute that exists today, 93104, which states that when any state officer or employee is transferred from one official station to another within the state of Wyoming for permanent duty, when the transfer is made at the request of or for the benefit of the state of Wyoming, the employing agency shall pay the actual expenses of transporting the household goods of the officer or employee. Interesting, Mr. Chairman, that across all these agencies that we oversee in the work we do here, there are some inconsistencies. I know that might surprise you, but there are inconsistencies out there. And I think that in part is what was the genesis of this little bill. So let's go to Senate File 9. And you'll notice that we modify the language that I just read to you. And the heart of the bill is on page 2. And what it says is, it clarifies that when the transfer is made as a requirement of employment for the state of Wyoming, it seems reasonable that we would provide some expenses to move that employee. And Romanet 2I is where the bulk of that language is. At the discretion of the administrative head of the employing agency may pay an amount not to exceed the amount allowed by the Department of Administration and Information Policies. That was to try to eliminate, Mr. Chairman, some of that inconsistency that we found across agencies. And for the actual expenses, a portion of the actual expenses, et cetera, et cetera. That is the gist of the bill. Mr. Chairman, specific to the Department of Transportation, there's a very diverse workforce out there. It's distributed throughout the state. And the department has encountered some difficulty in recruiting and retaining and advancing their qualified personnel. And so just seeking a little bit more clarification, they encouraged the Transportation Committee to take this up. It seemed reasonable enough to your Transportation Committee this past week. And so we forward it to you for your consideration. I'll do my best, Mr. Chairman, to answer any questions. Thank you. Thank you, Mr. Chairman. Since I moved it, I might just describe it to you.
You haven't moved it yet.
Yeah, I actually moved it when I moved the bill, Mr. Chairman, I believe.
We had to read it in, so.
Read it in, but I'll move it. Yeah. I'll move Standing Committee Amendment number 1.
It's moved.
Am I clear to go, Mr. Chairman?
You know, this is pretty complicated. We miss this one, it take a while.
I tell you, it's a pretty small bill and I'm turning it into a marathon here. My apologies. Mr. Chairman, I would move the Standing Committee Amendment. It comes in on page 2, line 10. And on one of your screens, if you'll look at the amendment, it simply deletes rules and inserts policies. That's related to what was asked by Administration and Information. They actually have policies in this regard, and it needed to refer to policies and not the individual rules of agencies. So that's what the Standing Committee Amendment does. I would ask for your favorable consideration, and then we'll go back to the bill. Thank you.
Thank you. We're on the Standing Committee Amendment number 1. Is there discussion on the Standing Committee Amendment? There is. No, there's not. Okay. Are you ready for the question?
Please.
Question is, should the Senate adopt Standing Committee number 1 to Senate File 9? All those in favor say aye. Aye. All those opposed say no. Motion has carried. Amendment is adopted. We're back on the bill. Senator Landon.
Mr. Chairman, thank you for navigating me through that process of that Standing Committee Amendment. And I would, again, stand for whatever questions might exist on this little bill.
Mr. Chairman, my question is how much is this little bill going to cost? Mr. Chairman, all the fiscal note tells me is that the agency that is proposed this is in favor. But it doesn't enlighten us on the issue of how much it's going to cost. And given our circumstances, I think it's a question we have to ask, Mr. Chairman.
Senator Scott, Senator Hutchings.
Thank you, Mr. Chairman. My question is also on that line. When it comes to the cost of these moves, we see this is for not only for officers of the state, but all employees. And I'm wondering if one employee is going to use this, then we know all of them will want to use this. And I also want to bring up the fact that we can move someone from an apartment from one part of the state to the other. And we could also move someone who has a ranch with 5, 10, 15 horses, cows, sheep, goats, whatever. Will all those be included in on the move? And yeah, that was it, Mr. Chairman.
Thank you, Senator Hutchings. Senator Landon.
Mr. Chairman, thank you. I'll try to answer those questions. To the senator from Laramie County, I'll take that one first. I would just call your attention to line 7 and 8 of Romanet numeral 2I, at the discretion of the administrative head of the employing agency. I think I can speak for the committee in saying that we felt like that was assurance enough that this would rise to a level that if we needed moving expenses to recruit somebody from the northwest corner of the state, for example, to come to Cheyenne, that's when this bill would for the most part come into play. If it's a crosstown thing, I don't ever imagine that this would be a factor. You know, regarding my colleague from Natrona County, that's a great question. And seeing that there is no fiscal impact that's been determined here, we did ask that question. And the answer that we got was, this is actually fairly prevalent, but it is kind of all over the map from agency to agency. And so we tried to give the flexibility in the language here. If it needs some help, we can certainly revisit on second reading if we want to pass it through the committee of the whole. And I'm sure that the Transportation Committee would be open armed with any thoughts we have to tighten it up further. But this does take place now. I read you the language at the beginning of the explanation of the bill. So we have it in statute now, and it is utilized. And this was an attempt to try to make it consistent under A&I, but also give some discretion to the agency heads. I hope that comes close to answering your question.
Thank you, Senator Landon. Senator Nethercott.
Thank you, Mr. Chairman. I just would direct the body's attention to page 2, line 3. When the compensation is limited to the transportation of household goods. And so I think that is the protective language. That isn't new, but the protective language, so you're not moving someone's ranching operation. It's simply their household goods.
Thank you, Senator Nethercott. Senator Schuler.
Thank you, Mr. Chairman. Just a question. I know we've done this in the past, apparently. I've just wondered if any of the state agencies had ever looked at the possibility of trying to put that into the contract, negotiating the contract with that aspect rather than having something separate like this, because I know private companies do this all the time, but it would just seem like it would be a better use of taxpayer money if we would let the department heads maybe try to negotiate something in the contract for that rather than have something separate. But I just don't know if they've ever looked into that or not. Thank you, Mr. Chairman.
Thank you, Senator Schuler. Senator Pappas.
Yeah, Mr. Chairman, just to that point, a lot of these employees are already employed by the agency. And in the case of YDOT, they're moving them around. They may have a district engineer that they want to move from one district to another district or bring him to Cheyenne to headquarters. That's the intent, is for the directors of the agencies, especially YDOT in this case, but to be able to manage their force, to manage their manpower, and to actually put the right people in the right place. We spent a lot of time bringing engineers, from young engineers, and then make them district engineers and move them on. We don't want to lose that talent. Sometimes we need to bring them to headquarters. So the intent is to manage the force. And since there is no appropriation, certainly the agency has to take it from the funds that they already have. And so I think it's incumbent upon us to allow the directors of the agencies to be able to manage their force and manage their manpower the best way they can. And we hire these directors, these people who are running our agencies for that purpose. I mean, they have to make those kind of choices, whether those dollars are important enough to move that person here. So I think it's a win-win. As the good senator from Natrona County said, they're doing it already. This puts just a little bit more structure. And if you recall, it's up to the employing agency. They may do this, so it's not a shall. Thank you, Mr. Chairman.
Thank you, Senator Pappas. Senator Hicks.
Yeah, Mr. Chairman, I just am trying to understand the need for this bill, because they can already do this under existing statutes if they recruit an employee to move them. The only thing that I can see that this adds is the language on page 2, line 7, at the discretion of the administrative head of employing agencies. And I would just tell you, my concern is we've got almost 90 some agencies. And so you're going to have 90 different potential policies out there. And I'm worried about the perception of parity from one agency to another agency. I'm worried about an administrator that may look more friendly for one employee than he does another employee, even within an agency. And it particularly concerns me that we haven't had input from all the other agencies. What I'm hearing from is this is a YDOT bill, and we haven't heard, and maybe the committee can help out. Did A&I come and provide testimony on this? What have we heard from other agency directors or heads of agencies? Is this something that would be a useful tool? But it looks to me like we can accomplish everything we currently do. And I agree that the little cleanup up at the top makes sense to me and Roman et al. I just worry about having 90 different policies amongst all the agencies, and then how the administrator would even implement that equitably within an agency. So if we can have a little discussion on that, it'd be helpful for me, Mr. Chairman.
Thank you, Senator Hicks. Senator Papa.
Mr. Chairman, thank you. And to that note, the intent of the bill is actually to keep us from having 90 different policies. The intent here is to allow A&I to develop those policies so that they are consistent across all departments, all agencies. And so I think that's the gist of the bill. Since the department heads are already allowed to, or the department directors are allowed to be able to use their funds for travel expenses. The issue is how they do it. And so the intent of the legislation is to allow A&I to provide policies so that every agency can be on the same playing field. So that's exactly the intent, is to get us on the same page.
Thank you, Senator Pappas. Senator Dockstader.
Mr. Chairman, if what was just said is correct, and the consistency is there, and I'd like the sponsor, the chairman, clarify that if that's what we're doing, because that does change intent a little bit. And I'd like to make sure that that's exactly where we're going. Out in the far west, our concern is not a moving expense. It's just trying to find a place that's affordable to live. That's moving expenses. It's not even in the ballpark. Just trying to find affordable housing. Thank you.
Thank you, Senator Dockstader. Senator Landon.
Thank you, Mr. Chairman. You know, the president brings up a very important point that exists all over the state, really, but certainly is at a fever pitch over on the Western Front. And so this moving expense becomes even more important when it's all you can do to even find housing. And quite honestly, it's not always, you know, transferring from the president's district down here to the state of Wyoming that we're talking about. We might be trying to transfer somebody from here up to his house up in the Great Valley. So you know, you do have the issue, unfortunately, to the senator from Baggs. You've got an issue all across the board that we run into in appropriations in particular, but other committees as well, that agencies are a little bit all over the map. We have had testimony that if we don't have ANI at least take a look at this, we do have disparate things going on out across the agencies. And this is a step, I think, in the right direction. It may come back to us from ANI that we need to do a little bit more work, and that's fine. One of our committees can do that. But I think this is a good step, and it does take us in the right direction, Mr. Chairman. Thank you.
Thanks, Senator Landon. Senator Bouchard.
Thank you, Mr. Chairman. You know, one of the things I've always kind of stood by is if I listen to what they say, how do they benefit? And I just wonder when I see language, it says at the discretion, so that we're starting there, at the discretion. And then it says may pay an amount not to exceed. I don't know what that does. It says at someone's discretion, they may. I mean, we're not really doing anything here except maybe making it more convoluted. I think that there are some rules in place that we haven't even looked at. We should see the rules in front of us today so we know what we're looking at. So I think if we're going to do this, we should be very specific. There should be procurement. There should be things that we do to make sure that things are done uniformly, and we're doing that here in setting policies. So I'm still trying to come back and figure out where this is going, because this doesn't look clear to me when I look at the language. Thank you.
Thanks, Senator Bouchard. Senator Pappas.
Yes, Mr. Chairman. The ability for them to do that right now is there. They're making these judgment calls. We hire directors to make judgment calls on everything that agency is doing. Okay. The intent with this legislation is, and by the way, the rules, we've changed it to policies. We did, and to the question about did we have any input from ANI? Yes, we did, and that was one item that came up. To go and put a lot of this stuff in rules. There may be caps, there may be certain things that they want to put in there. Those things would be adjusted periodically. And so to put them and to formulate rules, it's a long process for them to have to keep changing it. So that's why they suggested we make policies. And that's what we have right now since we passed the amendment. But it's really an attempt to make sure that every agency head knows what the ground rules are for expending funds for moving personnel. And right now, that's not available. When ANI does their homework and publishes policies, then hopefully we'll be on a level all the directors will be on a level playing field. They'll know. But they are the directors. They have the ability to expend those funds or not, just like anything else in their agency. And we hire them to make those choices. So I don't think we're making this more convoluted. We're actually clarifying it by adopting policies that ANI will eventually produce. Thank you, Mr. Chairman.
Thank you, Senator Pappas. Senator Landon?
Thank you, Mr. Chairman. Just a final thought or two. With regard to the permissive language, fair enough, and granted, the senator from Laramie County, I totally get that. And sometimes we do have to put some faith in our agencies out there. In this particular case, it will be ANI to establish some rules that our agency heads can rely upon. The permissive language, by the way, with regard to how much we can extend for moving expenses, it's all related to the fact that some of our agencies can do this and some can't. And even more so going forward, that may language, there's no shall in there because we may not be able to provide many moving expenses for any agency, but at least we're going to develop, some consistency through our ANI. And so I hope that helps. Thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Hicks?
Yeah, Mr. Chairman, and I'm reading this and I'm not getting to where the discussion's going because it comes back and it says at the discretion of the administrating head of the employing agency.
Keep reading.
Mr. Chair, I agree. May pay for the amount not to exceed amount allowed by the Department of Administration and Information if we adopt the amendment policies of actual expenses or patients. So if we want a consistent policy, you just strike the first right up through agency on lines 8. And it says it sets the policy. ANI is going to reimburse it. They'll set the policies. That's what they're going to pay. As long as you leave that discretionary component, you're going to have 90 different policies because it's a discretion of an agency head now to even go to ANI to make a recommendation. And that's the way I read the bill. And if I'm not reading it correctly, somebody needs to point me out. But it is completely at the discretion of the director to go to ANI and even ask for that level of funding. So, Mr. Chairman, and maybe I'm reading it wrong, but that's the way I'm reading the bill.
Hey, thank you. Senator Hutchins.
Thank you, Mr. Chairman. I know this seems like such a simple bill, but something I just noticed on page 1, lines 13 through 15, it actually deletes when the transfer is made at the request of and for the benefit of Wyoming. Can the bringer of the bill please explain that? Thank you, Mr. Chairman.
Thank you, Senator Pappas.
Mr. Chairman, to that point, I would point out that if you look on page 2, lines 4 and 5, it's just in a different location. And then to get to the point from the great senator from Baggs, the discretion is very, very important. We have to give our department heads, our agency heads, discretion. As I mentioned earlier, that's what we hire them for, to make those kinds of decisions. Some agencies may not have the ability or may not have the need to actually move people very often. And so it becomes something that's not necessary in that particular agency. If you take away the discretion of the director to be able to expend those funds, you've just tied his hands, because then everybody will want to tap into those funds, right? They'll want, I'm going to move. So the intent here is when the department makes the transfer of the employee from one location to another location to help build his force, manage his employment and his workforce and his ability to be able to provide the funds to transfer that person is something that has to be discretionary. It's his call. He gets the big bucks for doing that. So I feel very uncomfortable taking that discretion away from our department heads. Thank you, Mr. Chairman.
Thank you, Senator Pappas, Senator Landon, excuse me, Senator Bouchard. Let's go back to Senator Bouchard and then maybe Senator Land can bring this home. We can bring us to a vote. Senator Bouchard.
Thank you, Mr. Chairman. You know, I really don't think this bill matters a whole lot either way. I will tell you that what does concern me is that we're going to the trouble to make a bill and we're not saying what series of money we're going to spend this out of, how we're going to track it. Is there procurement involved? Is there provisions not to be in some contract with someone who may be in a conflict? Those are the things that concern me. If we're going to go to the trouble to do a bill like this, we should just make the policy, make it uniform, make it statewide. Thanks.
Thanks, Senator Bouchard. Senator Landon.
Mr. Chairman, this may be the last thought or two on this bill.
I don't know. The ground seems, we've plotted several times, but you know, who knows?
Yeah, it's you and me, baby. It's you and me. Mr. Chairman, thank you. And I do appreciate the debate on this bill. What I would anticipate to my friend from Bags is the Department of A&I will come with some rules and regulations that not only stipulate if you're going to pay the moving expenses, you have the ability to do that. But if you're going to pay less than that, there probably are going to be some caveats embedded in the rules and regulations that will give some direction to these agency heads. The permissive language, again, I agree with my good friend from Cheyenne. You have to give some discretion there because we're not going to have the budgets that we used to have. And maybe they can help, maybe they can't, but we certainly don't want to write into statute that we're absolutely going to shall do this. With regard to the depth and breadth of the senator from Laramie County, I would say that not very often do you find statutes getting down to that level, because a lot of what you point to, you're absolutely right. All of that comes into play, what's written into contracts, what negotiations take place between agency heads, prospective employees, all the way down through the rules and regs of A&I or the Department of Transportation. And I would argue that a lot of that kind of thing sometimes doesn't belong in a statute. But Mr. Chairman, thank you. I would call for the question on the bill. Thanks.
Are we ready for the question? All those in favor of Senator Landon's motion with the committee whole rise to report that with a favorable recommendation on Senate File 9, say aye.
Aye.
All those opposed say no. Motion has carried. Senate File 9 has passed committee of the whole. Mr. Majority Floor Leader.
Mr. Chairman, I move the committee of the whole beg leave to rise and sit again.
For the motion, all those in favor say aye.
Aye.
All those opposed say no.
No.
Motion carries.
Mr. Majority Floor Leader.
Mr. President, I move that the Senate stand recessed until 2 p.m.
Are there any announcements? Announcements? Senator Grew, are you okay?
Mr. President, Senator Anderson.
Senator Anderson, go ahead.
Mr. President, are we going to report on our committees? Is that in announcements?
Yes. tell us what your committee will be doing, please.
Okay, all right. Mr. President, your favorite committee, Minerals, number 9, will not meet today at noon, but will meet Wednesday at noon to hear Senate File 99, Senate File 111, Senate File 113, and Senate Joint Resolution 2 and Senate Joint Resolution 3. Thank you, Mr. President.
Thank you. Senator Wasserberger, you have an announcement? Senator Wasserberger, Senator Cost, you have an announcement? Thank you. Senator Landon, do you have an announcement? Go ahead.
Mr. President, your Transportation, Highways, and Military Affairs Committee will meet this afternoon upon adjournment to continue Senate File 7, autonomous vehicles. We will also take up Senate File 106, transportation statutory amendments, which was just read in this morning. We will also take up Senate File 107, transportation statutory amendments 2, which was read in this morning by yours truly. So we will have 3 bills that we will take up, Mr. President, upon adjournment. Thank you.
Thank you. Senator Hicks, you were standing. Do you have an announcement? Senator Hicks, you're standing. Do you have an announcement? Okay.
First time ever.
I remind everybody, stay seated until we're done. Thank you. All right. That concludes our announcements. You've heard the motion. All those in favor say aye.
Aye.
Those opposed, no. Senate will stand recessed until 2 p.m.